It's not a public workshop.
You just said it was a city meeting, so it is or isn't a city. I'm just trying to understand, sir.
Not a workshop. It's a meeting held by the city. It's a closed meeting. There is not 3 public officials, not even 2 elected officials here. Okay, there's only a single, and I'm here till 12:30, and then I leave. So
Okay.
that's how the meeting is. And I'm
You're
just-
waiting outside.
It was on the website this morning
I'm
as a
aware it was
workshop.
on the website.
Yeah.
I'm aware they're changing the
This
rules on the
is
website.
the city of Satellite Beach working with us.
This is transparency right here.
It is. It's a meeting.
It's-
It's a city meeting. It's not an open meeting. There's
Case 2018 CA 47523. Crystal Bailey, Jeffrey Dubitsky, Florida Health Connection LLC versus City of Satellite Beach, Frank Catino, Mark Bremer, Mandy Gibson individually. And from what I understand from the materials provided to me that I was reviewing is that their defendants have multiple motions for attorney's fees. And as my want, normally if someone calls and asks for multiple hours of hearing time, and I say no. First, we'll have a hearing on entitlement before we have a hearing on their amount, and is the hourly rate good, and did we spend 2 hours drafting a complaint when it should have been an hour and a half? That sort of silliness. So I understand and I appreciate the attorneys then that this is limited to both the entitlement argument, but even further limited on the front end here to an argument whether from the plaintiffs that the law of the case doctrine would apply to preclude the court from even having further hearing on entitlement. Is that correct, Mr.
Yes,
Bedoni,
Your
Mr.
Honor.
Beadle?
Yes, Your Honor, that's correct. And we figured we'd short circuit that issue and just deal with that today.
Okay. Appreciate that. Appreciate both the intelligence and the collegiality. Right. Now, in reviewing the materials, though, I kept going through the notebooks, wondering if I was missing something. I have a memorandum of law then submitted by Mr. Bedoni that eventually gets to the law of the case argument about page 8 and cites to a handful of cases. Am I missing a memorandum of law from the defendants on the law of the case doctrine?
Your Honor, we didn't provide one. We provided you the
Okay.
case law that we're going to, then the statutes that we're going to rely on in the argument, but we didn't actually provide a memo.
Okay, and that is SC Moda versus Moda Pizza.
And there should be, well, there's other ones in the packet I submitted to court also in the binder. They're at the end of the binder, and then the 2 statutes that are applicable are also in the binder.
Okay, thank you. Thank you. All right, Mr. Bedoni then.
Yes, thank you, Your Honor. So I want to talk about just kind of the bedrock principles of the law of the case doctrine before we get into the nitty-gritty as to how that applies here. The SC Moda case provided by Mr. Beadle says, quote, the doctrine is limited to rulings on questions of law actually presented and considered on a former appeal, unquote. Also, the Florida Wellness case talks about how the doctrine, quote, applies to issues explicitly ruled upon by the appellate court and to those issues that were implicitly addressed or necessarily considered by the appellate court's decision, unquote. And the Florida Wellness Center also talks about how it really applies to issues of law, but not really issues where we need findings of fact. Since the appellate court is not really a fact-finding court, you really can't have law of the case where you need additional facts to make a determination. So the court there held, quote, the determination of whether a prior appellate court ruling on attorney's fees binds a lower court depends in part upon the type of fees requested and whether a ruling would require the courts to make findings of fact, unquote. So here, we had a case where the court dismissed a public meetings law complaint under the analysis that I needed, or at least the claimants, me representing the claimants, needed to allege that the city council members in attendance at the meeting needed to have a discussion amongst themselves, and that holding is not present anywhere in the law. It is suggested in dicta, but it is actually contradicted by the Times case, as cited in my memorandum, which says that you don't necessarily need to have a discussion in order for a meeting to exist. When the court considered all the arguments, the court essentially decided that the Canny case by the Florida Supreme Court, even though it approved the Times case, which said you don't necessarily need a discussion, that the Canny case sub silentio overruled the Times case to say you need a discussion amongst the members. That's kind of what happened at the trial court level. It went up on appeal. The 5th DCA issued a per curiam affirmance. The city filed a motion for attorney's fees under statute 286.011, which permits the city to recover attorney's fees if the court finds it was filed in bad faith or frivolous. The bad faith section being something that requires issues of fact, frivolous subject being something that can be determined solely on what the law is. So when the city filed its motion for attorney's fees, they cited their motion filed in the lower court, and they also made the argument in their motion at the appellate court. They say under 2.86.011 subsection 4, get there. They're entitled to attorney's fees because the claim below, as well as the appeal, quote, ignores years of precedent of the Florida Supreme Court, the District Courts of Appeal, and the Attorney General of Florida, and makes no attempt to distinguish that authority, unquote. And then it incorporates the motion for attorney's fees and costs filed on March 15th, 2021. That motion is a motion under 57.105, arguing that the case is frivolous.
So it's incorporating a trial court motion for attorney's fees. Yes. Under 57.105.
Yep.
Yep. So let me ask you this. I don't know if this is splitting hairs, but when we talk about city filed a motion in front of the appellate court under 286.011, is the appellate court making its ruling, making a determination that the appeal would have to be frivolous to grant fees, or that the appeal and the underlying action would have to be frivolous to grant fees, or that only the underlying action would have to be? That seems like the least possible, but is it possible that the appellate court, in ruling on the motion asking for fees, is making a ruling that they're not finding that the appeal is frivolous, it's denied, and it doesn't necessarily extend to the underlying action?
Well, I return to the text of the statute, and the text of the statute and what the 5th DCA decides is, quote, whether, quote, the individual filing of such action was filed in bad faith or frivolous. So they would need to make a determination as to whether the claim below was frivolous. That would necessarily be the thing that they are determining under that statute, which is also the same argument being raised in the 57.105 motion by the city. And there are maybe certain things in the city's motion that require facts, but solely on the issue of law. Was the action frivolous? That issue was litigated by the city. It was they incorporated their argument pursuant to 57-105 at the trial court level and had the 5th DCA review whether the action was when it was filed was frivolous. That's the standard for 28.011 subsection 4. And it's largely the same standard that you have with 57-105. That 57-105 can get a little more specific in the sense that if the claim is not supported by facts, you can attack that through 57-105, and it also can attack individual arguments made rather than here where it's just determining whether the action was frivolous. So, for example, I file a discovery motion, but the underlying case was valid. That underlying discovery motion won't necessarily be something subject to the analysis in 28.6.011, whereas it can be under 57.105. The individual defendants, the city council members, made similar arguments. They made their arguments under Florida Statute 286.011 subsection 4 in front of the 5th DCA. They made clear that that statute allows them to recover attorney's fees if the claim was frivolous or brought in bad faith, and they similarly incorporated their motion for attorney's fees filed below, which was the May 14th, 2021 motion for attorney's fees. So the Florida Appellate Court clearly reviewed whether the claim filed by my clients were filed. Well, I don't know if they could determine whether it was filed in bad faith. I think that needs additional facts, but I think they definitely, under the statute, can determine whether the claim was frivolous. And so we need to get into the case law. The first case, I think probably the best case to start with, is the Florida Wellness and Rehabilitation Center case from the 3rd DCA from 2019. Again, it talks about how the law of the case doctrine applies not only to those issues explicitly ruled upon, but also those implicitly addressed. It held that the determination of whether a prior appellate court ruling on attorney's fees binds the court depends in part upon the type of fees requested and whether a ruling would require a court to make findings of fact. It relied on 3 cases, the Salta investment case, the Langer case, and the Pompano masonry case. I'll refer to Salta as Salta 2. The Salta 2 case reversed an award of attorney's fees after the appellate court denied such fees. In doing so, the 3rd DCA ruled, quote, both parties' motion for attorney's fees made to this court were denied. This denial of fees is conclusive as to that issue and controls as to the fees awarded in the instant case. The Langer case reversed the fee award because, quote, the attorney's fees in this case were denied during the original appeal on the merits under the same statutory provisions that the trial court determined would entitle Fells to a fee award at the trial level. And the Pompano masonry case, there the 4th DCA expounded on its previous precedent concerning the law of the case, and it said that the The law of the case doctrine did not apply where evidence concerning bad faith was required at the trial court level and not presented through record level evidence at the appellate court level. In doing so, the Pompano court held that the law of case applies to legal issues, but not factual issues that can be determined by the trial court. For example, the Pompano case cited the McNamara case and said, quote, the statute at issue in McNamara involved a sanction centered around factual determinations by the trial court. This court's rejection of attorney's fees under the sanction was not binding law of the case, unquote. So essentially, under the Florida wellness case, you get this regime where issues of law determined by the appellate court, those are binding. If there's any sort of additional factual issues that are required to address an attorney's fee issue, then that will not constitute law of the case. The Mr. Beadle provided the SC Moda case, which is probably the most recent case. That case, you really need to understand the facts in order to understand what the holding is. There, the landlord filed an eviction action against the tenant. The tenant filed a class action against the landlord and the landlord's property manager as a result of that eviction action. The property manager filed a 57105 motion alleging that the tenant's alter ego claim was not supported by material facts. Was the first 57105 motion. Then the property manager and the landlord both filed a 57105 motion alleging that the discovery showed that the tenant did not have standing to bring the class action. Eventually, the trial court denied the class cert. The tenant appealed. The appellate court issued a PCA on that issue, and it denied the landlord's and the property manager's motions for sanctions under Florida Rule of Appellate Procedure 9.410, which, for the record, is a rule that allows for discretionary attorney's fees. It's not mandatory. There, the court holding reversed the law of the case's application by the trial court because it said that the appellate motion for sanctions proceeded under Florida Rule of Appellate Procedure 9.410, which permits the appellate court to deny motions for sanctions, quote, without deciding whether the interlocutory appeal was frivolous, unquote. So the real issue in SC Moda is where you have where the trial court has discretion, such as that rule of appellate procedure, to rule and decide not to even consider the issue about whether the claim was frivolous, then you aren't necessarily going to be in the law of the case. Mr. Beadle also has the Shucks versus Smalls case. It's what a fourth DCA case from 2012. There you also have a very fact-specific case that you need to understand those facts in order to understand the ruling. There you had a probate case, essentially litigation in a probate case. There was you had Smalls, who used to be the personal representative, and Shuck and a few other people who the court calls the appellants, who filed in the lower court a petition for revocation of the probate, quote, raising claims of improper execution of the will, lack of testamentary capacity, undue influence, invalid designation of the personal representative, and interference with estate administration. So essentially, they didn't like the will and were throwing everything that they can at the wall to see if it would fit. The Smalls filed a 57105 in the lower court saying you don't have any facts to support those claims. The case proceeded, and the court made a determination on the apportionment of taxes, which doesn't necessarily need litigation regarding the issues of improper execution of the will and all that kind of stuff. So that issue of the apportionment of taxes, that went up on appeal. It was affirmed, and a motion for attorney's fees as a sanction under 57-105 was denied by the appellate court. Then it went back down, and I think the court denied 57-105 fees. It went back up on appeal. On appeal, the 4th DCA reversed and said that the trial court was required to hold the appellants liable under 57-105 because the claims were frivolous, because they were time barred. Essentially, it was a clear-cut issue. It didn't really have any discretion there, so they needed to issue that 57-105 motion for sanctions. And they held that the law of the case does not apply. From the statement of facts, it appears that the issue held by the Shuck case is that the issue of untimely claim would have not been possible under the 57-105 claim for the first round of appellate review. But when it came around on the second round of appellate court review, they held that it's such a clear-cut issue that the attorney's fees under 57-105 should issue. So what's suggested by the Smalls case, or the Shuck versus Smalls case, is the issues under the first appeal weren't the same as the issues under the 57-105 litigated after the appeal.
Mr. Bedoni,
Yes.
I mean, this is a 30-minute hearing, and I have 3:45 hearing. I have a 4 o'clock hearing today. How are you not way over time?
I apologize, Your Honor. May I just close with one other point?
Okay.
There's the case, and I'm sorry I didn't provide it in my materials. There's the case of Landry versus Countrywide, Inc., 731 Southern 2nd, 137, which talks about the use of the word may in a statute. Actually, it's talking about the use of the word may in 57-105. Reciprocal fee provision for one-sided attorney's fees contract, and it says that the use of the word may is actually just making mandatory the attorney's fees once there's a determination that there's a prevailing party and there's a statute that applies. It's worth noting that case because 28.6.011 uses the same type of word may, but in terms of how it's construed under the Landry case, that use of the word may is just there to say, after the court makes a determination that it was frivolous, that's where the discretion is, the may. But once it makes it a determination that it's frivolous, then the court must award the attorney's fees. And so,
All right, let me hear from Mr. Beadle.
Yes, Your Honor. I'll respond to that comment first. As far as statutory interpretation, we would disagree with that. The statute regarding 286.011 makes a distinction within the text of the statute that says that the court shall assess fees against the agency if the determination is made there is a violation under 286, and then it says it may assess a reasonable fee against the plaintiff in that case. So we totally disagree with the interpretation that plaintiff's counsel is placing on that statute. Also, that is a discretionary statute under 286, whereas under 57-105, if a determination is made that after an evidentiary hearing that the court finds that a party's position is unsupported by material facts, then the court is required to order fees. So there's a distinction between the fee awards under both statutes. As far as the distinctions that are trying to be made regarding these cases, Shuck versus Small, there's a specific statement in the case, on the last page of the case opinion. It says, we also reject opponent's arguments that law of the case doctrine precluded the award of section 57105 fees as to the tax apportionment issue at the trial level. A prior denial of appellate attorney's fees under section 57105 does not preclude a trial court's award of trial court or trial level attorney's fees in the same action under section 57105. While an appellate court's prior denial of appellate fees under section 5105 is the law of the case, the appellate level fees, as for appellate level fees, it is not the law of the case for trial level. And it cites a third DCA case in support of that proposition. The Moda case was cited primarily because it talks about, again, in the last paragraph, in that case, as counsel indicated, there was a PCA and a denial, but there were no recitations as to what the predicate for any of what the opinion was, and there was no statement as to what the basis for the denial of fees was. It says, despite the tenant's representations below to the contrary, this court did not specifically address any of the arguments raised by the landlord or the property manager in the per curiam afference or in the unelaborated order denying sanctions. Consequently, the law of the case doctrine is inapplicable. So based on those two, and that's for identical bases for the fees. In this case, the appellate fees were sought under 286, and as indicated in our argument anyway, the appellate fees, the fees under 286 are permissive. Like the other distinctions in the cases are in SALTA 2, which was cited by plaintiffs. There's no facts in the case indicating what the basis for the court's decision was that there was a law of the case in the appellate opinion. Langer versus Fells is not helpful either. In that case, the court held that a fee award pursuant to the probate code were not authorized in the trial court where they were denied on appeal. Basically, that court looked at the fact that there's a predicate for fees under a statute, and if you comply with those requirements, you're automatically entitled to fees. And that was a distinction that the court made in there. And as noted, and actually the Pompano Masonry also allowed fees under the same, I believe it was a rule 1.710 for both, they denied that under the appellate fee request, but determined that it was allowed to move forward under the trial court. So when you look at the case law and the language of the two statutes as applies to this case, we don't believe there's any basis for plaintiff's position of the law of the case precluding us from moving forward on our attorney's fees. I could add more, but I know your time.
What was the site for Langer?
Langer.
It's 93 Southern 3rd 1069. I believe it was in the materials that I provided.
Yeah, I have it with my materials as well, Judge.
93 Southern 3rd.
1069.
Yeah.
Mr. Shepard, are you kibbutzing or are you joining in?
No, I'm joining in, but I promise I'll be brief. Mr.
Hold on a
Beadle
second.
covered.
What's the, we have people on the line for the.
We have 4 attorneys in court.
All right, but tell them there's going to be a few minutes. Go ahead and let them know it's going to be a few minutes. All right, Mr. Shepard?
Yes, sir. I will be brief. Lawyers should never say that. But I'm going to read you exactly the language of the statute that was at issue in the appellate fees. It exactly says that the court may assess a reasonable attorney's fee against the individual filing such an action if the court finds it was filed in bad faith or was frivolous. So, even had the appellate court thought Mr. Vadoni's appeal frivolous or in bad faith, it still wasn't required to issue a fee order against him. So that could never be, by its wording, law of the case. It is a discretionary act of the appellate court. It is completely unbinding. And on the issue of 57105, which is what Mr. Beadle is pointing out, but I just wanted to make the obvious point. You can't have law of the case on a discretionary act. It's simply not something that is available to you. Now, if you look at the motion that was filed by my client, or on behalf of my client, we filed that motion back on
Your trial court motion or your appellate court
our
motion?
trial court, the one that we're here on. The
Right.
trial court motion was filed in January of 21, and here we are in July of 23. Now, the unique thing about 57105, which Mr. Vidoni should be well aware, it requires that at any time, meaning before the appeal, after the appeal, at any time when you know or should know that there is no basis for your claims, you must withdraw them. And distinction from the statute that we were under on the appeal, when you knew or should have known that it's not support that the claims could not be supported by the material facts necessary to establish the claim, which is what the court found here, that the case should be dropped, which we didn't file this motion until after the second amended complaint. He'd already had two bites of the apple. He had to say in the complaint on behalf of his clients one simple thing, that the parties that he alleges were defendants discussed business that was relevant to this matter and part of the public record. He couldn't make that allegation. So on one hand, I'm thinking, okay, good. At least he's honest, because that's not what happened. And there was no evidence that that's what happened. But we had presented him with the law, not once, not twice, but a third time through the motions, both of which contained the 21-day mandatory notice, which if Mr. Vidoni had acted as he should have, after consultation with his clients, would have dismissed the claim. That's what should have happened in 21, and we're in July of 23. The award for fees when it's frivolous in 57105 or without a material fact in support under 57105 says that the court shall, not may, shall award reasonable attorney's fees, including prejudgment interest, and that's the difference.
I think, I believe Mr. Beadle was stressing that point also, and the difference between 57 and 286. All right, anything else, Mr. Beadle, Mr. Shepard?
Your Honor, if I may, just one minor thing. Mr. Vidoni indicated that we incorporated I don't think it's relevant because of the holding in Smalls, but the 286 motion we filed on appeal indicated that we were saying many of the grounds. We did not incorporate it by reference fully. It was just, we just made a general statement. So, but the basic predicate was 286, not 57105 on appeal.
Okay. Mr. Vidoni, you have brief rebuttal to any of those points?
Yes. So I do want to talk about the use of the word may. And this goes back to the Landry case. So the Landry case looked at the reciprocal fee provision in 57105 subsection, or that's currently in subsection 7, which says if a contract contains a provision allowing attorney's fees to a party when he or she is required to take any action to enforce that contract, the court may also allow reasonable attorney's fees to the other party when that party prevails in the action, whether as a plaintiff or a defendant with respect to the contract. So the 7 uses that same word may, and then follows about when that may comes into play. The way that the Landry case looked at that word may is as that it may, and then you have a determination as to when you may do that. Essentially, here in subsection 7, you make a determination of prevailing party. That's where the may comes into effect. If you make a prevailing party determination, then the attorney's fees are mandatory. So the Landry court says, it said, quote, if a contract contains a provision allowing attorney's fees to a party when he or she is required to take, it held that the word permissive use of the word may did not make the fees permissive. The permissive may only apply to the court's determination as to prevailing party. So applying that here, that same analysis is the word may really goes into the court's determination of frivolous, that it has the ability to make a determination of whether it's frivolous. And once it makes that determination, then it has to award attorney's fees. That would be pursuant to the same logic of the Landry case.
All right, thank you. Let me do this. I'll look back at it one last time. Well, there's no court reporter. Just candidly, I'll look back at it one more time because 7105 is a strong statute, and because now all of a sudden it changes the parties in a case. It includes the attorneys as presumptively being 50% responsible for the fees. But I'll look at your cases again. But this argument on law of the case is not my historical understanding of law of the case at all, in terms of whether it's discretionary or not, and also in terms of whether the appellate court decision states within some sort of level of particularity what the ruling is based upon, and not the underlying court having to try to guess at what it was. And then Mr. Shepard's emphasis on the point that Mr. Beadle had already made, though, I think is dead on in terms of my definition. When there's a discretionary aspect to it, can't be law of the case. But let me look at this, and I'll get back with you probably Friday. Okay?
Yes, Your Honor.
All
Thank
right,
you,
thank
Judge.
y'all.